let's go ahead and take the first call of the night. We have a call from Bonnie. Bonnie, please go ahead with your question.
My daughter was recently on an elevator. It fell and went back up 3 times. After the doors were opened, we found out that previously, maybe 10 minutes before, there had been 2 persons trapped on the elevator. And they called an emergency and had maintenance crew come there. In between the time they got these people out, my daughter got on.
Wow. So
that's a good example of notice.
that's huge.
I mean,
So would that manager be responsible for going in this? She said 10 minutes. I heard her say in 10 minutes time, would that manager be responsible for going to every floor and putting a sign and or something there to warn people?
Some states you have to have a more definite time period. In Mississippi, it's really just what is reasonable. But certainly something like an elevator, that could be very dangerous. If they have notice or knowledge, yes, they should immediately try to make sure no one uses the elevator. Maybe put up a sign, out of use. Whatever you got to do to warn somebody, don't get on the elevator.
But Bonnie is saying that she was injured in an elevator. Y'all, that's a really big deal.
They can be. In elevator and escalator cases, we've handled some of those, and what they really normally come down to is the maintenance records from the company, because they're supposed to inspect those regularly. They're supposed to make sure that they're functioning properly. Here, it sounds like there was some actual notice to the business or to the manager, and probably the better practice, so Bonnie or her family didn't get hurt, was to just put a sign on it and shut it down, because taking the stairs is not going to kill you.
Right. And so what advice would you give Bonnie? Who does she need to call and what does she need to do at this point?
2 things. I think they need to call a lawyer, but they need to do a notice letter. You want to talk about that?
Yeah, absolutely. So whenever you get a case, the first thing you want to try to do is send an immediate, what we call a preservation or spoliation letter. And what you do is you send it to the business, and what you want to ask them to do is to preserve any and all evidence. It could be photographs, video, witness statements, any kind of documentation, as Rocky said, maintenance records. You don't want that stuff to get lost, and the longer you wait to get it to them, the more of a defense they have that says, well, we didn't know we were supposed to keep it.
Right.
But if you get it out right away, they can't come back later and say, we got rid of it, or we destroyed it, we didn't collect it, whatever.
My dad was a lawyer, and he always told me that nobody ever loses evidence that helps them.
I got it. Right.
And so you got to ask for it quick, because they'll get rid of it if it hurts their case.
Yeah, and this could be a really big case because this may move into some kind of product liability with the elevator malfunctioning.
Could be.
Who knows?
Well, I was going to say, we've had cases where either the elevator has literally just dropped from, say, several floors. We've had where the elevator doors open and it's not flush, and someone has tripped trying to get onto the elevator.
Oh, wow.
We've had a lot of different variations of elevator cases, and we have an expert that we use who's very good. And lately, we've had about 4 or 5 that we've been successful on.
Really scary.
Yeah.
Really. Bonnie, please contact an attorney.